The original question was that the bill be now read a second time, since when an amendment has been proposed as on the order paper. The question is that the amendment be made. Mr. Kenneth Clarke.
Mr. Speaker, the opposition spokesman has just reminded us that this bill was trailed for a very long time as the Great Repeal Bill, which is a very unlikely title. Fortunately, when it comes here, it repeals hardly anything at all, which is one blessing. But one thing it does repeal is the European Communities Act of 1972, which is a particular irony for myself and no doubt for the honourable member for Bolsover as well, as we will remember that act. And I then was a government whip, engineering, mainly by cooperating with the Jenkinsite faction of the Labour Party, how we were actually to get that vote through against the rebellious imperialist Eurosceptics who were then on our backbenches. So it's an irony that a complete mirror image debate now presents itself to me rather many years later. But my starting point is again where the right honourable gentleman just finished. I have to accept that we are going to leave the European Union. I accept that because this House, passed by a large majority the resolution to enact Article 50. I argued and voted against it, but it went through, and it is idle to pretend that politically now it's going to be possible for that to be reversed. But the question now is how we do so. Now, I quite accept the basic premise of my right honourable friend, the Secretary of State, that technical legislation is going to be required to make sure it is practicable to get a smooth legal transition. I don't think that this piece of legislation confines itself to that aim, as has just been said. The result is that a bill of this kind is necessary, and I think we're going to have to vote for it. But the question is this particular form of the bill remotely acceptable? Now, I studied the amendments put down by the official opposition and indeed by large numbers of other members. And my conclusion was that I found myself agreeing with the overwhelming majority of the sentiments and opinions being put forward in all those amendments. The one thing that gave me a problem was they all begin with declines to give a second reading to the bill, which does give rise to the problem that it would stop any possibility of making the changes required. But I have to say this. Minded as I am at the moment to contemplate voting for second reading, I am going to need some assurances before we get there. In particular, that there is going to be sufficient movement to some of the unanswerable points that are being made about parliamentary democracy and a smooth transition to whatever the alternative is, for this bill to be anything other than a wrecking piece of legislation if it proceeds forward. I could console myself with the thought, I haven't decided yet, I'm actually going to listen to the debate, which is a very rare feature in this House, but I am going to listen to the debate, because, of course, if we were to defeat the second reading, well, the government would be obliged to bring back another bill to try to achieve the same purpose, and if the government isn't going to move in the next 2 days of debate, well, I think we may have to force it to go back to the drawing board and try again as to how to produce a bill which is consistent with our parliamentary traditions and actually does give this House the control that leaders of the Leave campaign during the referendum kept telling the British public they were anxious to see. Now, I hope I'm agreed. I'm not going to give way because there are large numbers of people wanting to speak, and I just want to touch briefly on this time constraint. When we sat through the European Communities Act, I've no doubt the honourable member for Bolsover, like me, sat through weeks and weeks, days and days of very high-quality debate. It was a historic moment, and it was not constrained by these Blairite notions of family-friendly hours and tight timetables and all this kind of thing. Now, I don't want to go back to the all-night filibustering and some of the nonsense that led to those practices being discredited. That's not suitable in the 21st century. But this government began the process by trying to argue that the royal prerogative enabled it not even to bring Article 50 before the House, and it's been trying to reduce parliamentary scrutiny and votes ever since the whole thing started. So let me give a first simple example. I raised with the Speaker a few moments ago the question of the 5 o'clock rule. Apparently we've all got to stop at 5 o'clock this afternoon. Well, it would reassure me about the government's intentions if the opportunity was taken to lift it now. The leader of the House only has to rise at some time in the next hour or so and say the 5 o'clock rule is not going to be invoked today, and all these constraints on time which we're all facing will not be a problem. But I hope the timetable motion for the bill also does not try to confine debate to a comic number of days, because the Right Honourable Gentleman's speech a moment ago has shown how complex some of the debates are going to be. And we don't want all to be told we've got to take part in legal analysis in 5 minutes flat, or be cut out by some quite unnecessary timetable. We've got at least to the end of 2019 to get these procedures right. Now, briefly, there are two broad issues, one of which I will leave alone. It's been dealt with brilliantly. One is, and it's going to dominate a lot of today, which is the Henry VIII clause, the sweeping powers, the extraordinary nature of this legislation. I won't try to compete with what I think, with respect, was the brilliant speech of the Right Honourable friend, the member who leads for the opposition, and I hope in the next 2 days of debate I'll hear some reply. I'm sure my Right Honourable and learned friend for Beaconsfield will touch on that, and my own analysis, which I preferred, of Clause 7 and Clause 17, I think is probably not up to the standards that have already been demonstrated. There's no point in repeating the case. I would therefore say one thing to my Right Honourable friend and his colleagues, the Secretary of State, who tried to reassure us that what I expect in response to that. We're told that conversations will be held with my honourable friend, the Right Honourable friend, the member for Broxtowe. I'm delighted to hear that. I'm told that we will have assurances about how ministers are going to use these powers. But at every stage in his speech, as my Right Honourable friend had to, he actually defended the wording he got. And he didn't make the faintest concession, either to the very justifiable concerns about the impact on devolution or to the even bigger concerns about whether we're going to fritter away parliamentary democracy in this House by passing the bill in its present form. So I have to say, I know my Right Honourable friend is sincere in his assurances. He's one of those people in this House I would trust actually to seek to deliver what he is offering to us. But the reality, as someone has already said, is we're all transient in politics. He will come under pressure from some of his colleagues. We have no idea who will be in office at 18 months' time in any particular post. And the letter of the law will determine to what scope there is for parliamentary scrutiny. So I don't want more assurances, I don't want more charm. What I want is positive amendments, changes to the... and the government will actually salve its reputation on this issue if it takes the lead and produces the amendments which answer the points already made by the Right Honourable and learned gentleman who just spoken for the opposition, and reassures us that the drafting was a misunderstanding and that better drafting can make it the no policy change, technically necessary bill that I would quite happily support. The second issue, very briefly, is the question of staying in the single market and staying in the customs union during the transitional period. Of course we're going to have a transitional period. Of course it's got to be a smooth transition. Of course by the end of 2019 we're going to negotiate a basis for future free trading arrangements. And I do think that just as the government's got to move, just as the opposition has moved. I made a speech on the Queen's Speech debate explaining why I was in favour of staying in the single market, staying in the customs union, at least for the transitional period, and I then answered the various arguments that are routinely thrown out. And so I won't repeat any of that. But it does seem to me there's only a whisker of difference now. I don't deceive myself that I converted the Labour Party, who now have put down an amendment identical to the arguments I was putting forward, which they didn't then agree with when we were debating the Queen's Speech. But when I look at the government's proposals, they're remarkably near, because we all know, British business knows, we need this smooth transition. We don't need change until we're certain we have some acceptable new arrangements. I won't read it all out, but I've looked at the position paper on customs arrangements put out by the government. And this says, I will read one sentence, this could involve a new and time-limited customs union between the UK and the EU customs union based on a shared external tariff and without customs procedures. Well, I won't go on. There's an absolute whisker of difference between the government's paper and what the opposition are now saying and what everybody of the slightest common sense, in my opinion, is saying, that we should stay in the single market and the customs union until we know that we can smoothly transfer to some new and equally beneficial arrangement. Again, I would like some reassurances on that. I detect in this wording, and I conclude with it, Mr. Speaker, I'm glad to say, I detect in this wording and the proposal and the amendment from the opposition, we're crawling towards that cross-party approach, which is obviously going to be required in the national interest to settle this. It is absurd for the Labour Party to say they're all agreed on the new policy they've adopted. It's absurd for the Conservative Party to say we're all agreed on whatever it is the Secretary of State is trying to negotiate in Brussels. The public are not idiots. They know that both parties are completely and fundamentally divided on many of these issues, with extreme opinions on both sides represented in the Cabinet and the Shadow Cabinet, let alone on the backbenches. Let us therefore resolve this matter. Let us make sure this bill doesn't rule out and make it impossible to stay in the single market and the customs union. Let us have some grown-up debate on the whole practical problem that we face and produce a much better Act of Parliament than this bill represents as before us at the moment.